Oh yay, oh yay, oh yay. The Honorable Supreme Court of Arkansas is now in session. All persons having business before this honorable court, draw near, give attention, and ye shall be heard. May God save these United States, the state of Arkansas, and this honorable court.
Well, good morning. The court has some cases to hand down today. We have CR 95-975, Jimmy Don Wooten versus State of Arkansas from Polk County Circuit Court. Petitioner's pro se second petition to reinvest jurisdiction in the trial court to consider a petition for writ of error quorum nobis. Petition denied. Justice Hart dissents.
CR 19-421, Robert Woodward versus the State of Arkansas from Chico County Circuit Court, remanded to settle and supplement the record. Justice Womack dissents.
CR 19-745, Matthew Armstrong versus State of Arkansas from Searcy County Circuit Court, affirmed. Justice Hart dissents.
CR 1964, Stephen Hayes versus State of Arkansas from Saline County Circuit Court, affirmed. Justice Hart dissents.
CR 19-591, Tracy Will Vaughn versus State of Arkansas from White County Circuit Court, affirmed. Court of Appeals opinion vacated. Justices Hart and Wynn dissent. CR 19-981, Curtis Dorsey versus State of Arkansas from Pulaski County Circuit Court, 7th Division, affirmed. Justice Baker concurs without opinion. In CV-20-13, Darrell Talley versus Wendy Kelly, Director of the Arkansas Department of Correction from Jefferson County Circuit Court, affirmed. Justice Hart dissents.
Will the clerk please read the submissions?
There are 9 appeals being submitted to the court for decision this morning, the first of which will be the oral argument. CV-19-979, Shelley Buoanauito and others versus Keith Gibson and others from Pulaski Circuit. Criminal case 20-294, Donald Capel versus the State of Arkansas from Pulaski Circuit. Civil case 20-499, David Tollett versus Jimmy Wilson and others from Pulaski Circuit. Civil case 20-527, Stay Strong Status Quo, a local option ballot question committee and others versus Pam Bradford and others from Van Buren Circuit. Civil case 20-546, Tom Steele versus John Thurston as Secretary of the State of Arkansas from Pulaski Circuit. Civil case 20-548, Stay Strong Status Quo, a local option ballot question committee and others versus the Van Buren County Board of Election Commissioners from Van Buren Circuit Court. Civil case 19-965, Tom G. Clowers versus Marilyn Edwards and others, an appeal from Washington Circuit. Criminal 20-137, Mark Robinson versus the state from Saline Circuit. And civil 20-83, Maurice Trammell versus Wendy Kelly as the Director of the Department of Correction from Chico Circuit. In addition to those 9 appeals also being submitted to the court for decision today are 22 other various motions and petitions, all of which are available on the court's website.
Okay, thank you. Our case for oral argument today is CV 19-979, Buoanauito and others versus Gibson and others. And the court recognizes counsel for the appellants.
Thank you, Mr. Chief Justice and Associate Justices. May it please the court, my name is Justin Zachary, and I represent Shelley Buoanauito, Mary Weeks, Verlin Abrams, and Sarah Thompson, the appellants. The question before you here today is whether the state's usage of tax revenue on project CA-0602, the I-30 project, and CA-0608, the I-630 project, is an authorized use under Amendment 91. A state agency's authority to act flows only from that given by the people. Here, The state's authorization to use these special limited tax funds comes from the language of Amendment 91 passed by Arkansas voters and its corresponding ballot title. The I-30 project and the I-630 project both propose to widen an existing 6-lane highway. The language of Amendment 91 and the ballot title put before voters, however, specifically limits the state's usage of these tax funds to 4-lane highways. The circuit court's decision below sidesteps the language of Amendment 91 in the ballot title to conclude that a legislative drafting error occurred and that these special limited tax funds could be spent on state highways regardless the number of lanes. The circuit court's decision should be reversed for 3 reasons. First, the language of Amendment 91 is plain and unambiguous that the funds generated by the amendment are to be used to construct and improve 4-lane highways. Second, the ballot title clearly told voters that the state's funds from the amendment were to be used for constructing and improving 4-lane highways. And finally, third, the circuit court went beyond the language of the amendment, the ballot title, and even the evidence below to ascertain that a legislative drafting error occurred. Language of a constitutional provision that is plain and unambiguous must be given its obvious and common meaning. The language of Amendment 91 is clear and easily understood. Amendment 91 specifically sets out the authorized purposes for which the state can use these special limited tax funds. Ironically, there are 4 authorized purposes found in Section 4 of Amendment 91. Section 4 clearly states—
Mr. Zachary.
Yes.
So in reviewing the circuit court's decision, it really honed in on the phrase 4-lane highway system and found that that was ambiguous. How do you respond to that in terms of allowing the circuit court to consider evidence outside the language of the amendment?
Well, I would respond to that in a couple of ways, Justice. One, a constitutional amendment must be interpreted as a whole. It shouldn't be taken as a one word in one section. And I think that was one of the errors that we believe the circuit court made. At no time did the circuit court reconcile his decision that a drafting error occurred with the authorization language in Section 4 or the definition section in Section 2 of the amendment, or even the ballot title, the language in the ballot title. The circuit court only found a drafting error in Section 1 of the Amendment 91. And this court's clearly stated before that we should not interpret a statement of intent by the legislature against the plain language of the amendment.
Thank you.
And the language of the amendment sets out the very substance here. One thing that we pointed out too is that the court, as this court stated a number of times, that each word has to carry meaning. So the language and the authorization in Section 4 has to have a meaning, just as the definitions in Section 2. And at no point did the circuit court reconcile the drafting error or any ambiguity that he found in Section 1 with the language in Section 4 and Section 2. The circuit court simply had to disregard those sections because you can't read the actual substance of the amendment and come to any other conclusion than 4 simply means 4. Now, laws are passed every legislative session for a general purpose, whether it be to create jobs, grow the economy. But the purpose of these types of laws is how is it going to accomplish this goal? Does Amendment 91 approve a state system of highways? Yes, absolutely. What appellees refuse to acknowledge in the circuit court below is how Amendment 91 was meant to accomplish that purpose. The how of Amendment 91 is specifically laid out in the ballot title in Section 4 in plain and unambiguous language: constructing and improving 4-lane highways. The plain interpretation of 4-lane highway is in line with how this court has routinely interpreted the term 4-lane as well as the underlying testimony of representatives of the Arkansas Department of Transportation. For example, Mr. Madison Murphy, the Highway Commissioner at the time Amendment 91 was presented to voters.
Counsel?
Yes.
But we don't have to look at any other interpretation of, and it's actually Section 4 refers to 4-lane highway improvements. We don't have to go beyond any other interpretation other than what Section 2 interprets it at. So if Section 2 plain and unambiguously says this is the definition of 4-lane highway improvements, then that's the definition. We don't go beyond that. Isn't that correct?
That is absolutely correct, Justice Wood. If the language of the amendment is plain and unambiguous, the court's interpretation stops there. We don't use interpretation tools to create ambiguity. Ambiguity must be found in the language itself. And so if the language is plain and ambiguous, the court's interpretation stops right there. That's exactly right, Justice Wood. To the extent, and it is appellate's position from the very beginning of this case that the language of Amendment 91 is plain and unambiguous. To the extent that there is any ambiguity in Amendment 91, the ballot title, though, clearly told voters that the state's portion of the tax funds were for the purpose of constructing and improving 4-lane highways. And I think that's a significant point because the ballot title is the final word of information to which voters had the right to look as to determine what authority they were going to confer to the state. The ordinary meaning attaching to the wording in the ballot title in this case clearly conveyed the message to voters that the state's portion of the funds would be used on constructing and improving 4-lane highways. This court has held just recently, last year, that any use of a sales tax revenue for purposes other than those designated by the levying law and the ballot title is in violation of Article 16, Section 11 of the Arkansas Constitution and constitutes an illegal exaction. Here,
Zachary, can we go back to what you were discussing with Justice Wood in terms of the definition? I think it is a little more challenging when we start to analyze the definition in subsection B that lists bridges. And I'd like for you to address that in terms of, what kind of bridge? Is that a bridge only on a 4-lane highway? How does that affect the I-30 bridge situation? Because, there's certainly a couple of different ways that council is presenting us to interpret that.
Sure. So Section 2G1 of Amendment 91. First, I believe before you get into the list, you have to look at Section G1. What exactly is being defined here? And what's being defined is 4-lane highway improvements. Then there's a list of what 4-lane highway improvements mean. And the very first thing listed, G1A, is 4-lane roadways. Things stick out when you go to law school, kind of stick out in your mind. I can remember being in class and hearing the term iustum generis, when you have specific words followed by more general words. Those general words are construed to embrace only objects similar in nature to those objects that are enumerated in the specific terms. Here, the specific terms are 4-lane highway improvements and 4-lane roadways. The general terms, bridges, tunnels, engineering, right-of-ways, are the general terms. Those are all components of a 4-lane highway. So when looking at bridges, you're looking at, yes, can they use it on bridges? Absolutely. Bridges on 4-lane highways. Nowhere in the amendment is it authorized for the state's portion of these funds to be used for anything but 4-lane highways.
Counsel, I think that what you're looking at is the statutory construction canon, which is the series qualifier canon. And that you're saying that because there's 4-lane in front of roadways, that 4-lane applies to everything on the list. But isn't it true that when they include that parenthetical marker of a semicolon, that then the qualifier does not apply to the list. I don't know if you're familiar with reading the law by the late Justice Scalia and Brian Gardner, that it says that qualifier would not apply to the remainder of the list. And if so, then Bridge stands alone.
And Justice, I would potentially agree with that, but I think you first have to start with G1. What are we defining? And we're defining 4-lane highway improvement. Now, 4 lanes not defined because it's really self-defining. What does 4 mean? It means 1 more than 3, 1 less than 5. And so I think even when looking at the list, you first have to look at what are we defining here? We're defining what's in G1, 4-lane highway improvements. Now, what does that include?
Counsel, if that was the case, then why would they restate the qualifier in front of roadways if it was so obvious that 4-lane was going to apply to everything on the list? If that's, what they were defining in G1, why would they restate it in A if they meant it was going to be applicable to everything? And as I said, if so, you would use a comma grammatically, not a semicolon.
I do see your point, Justice Wood, but I think when you read a couple things, when you read the section as a whole, and that the fact that the term 4-lane is used 30 plus times throughout the amendment, and then when you look at the authorization purposes, and then look at what we're defining here as 4-lane highway improvements, what is under 4-lane highway improvements? It's 4-lane roadways, and then it's bridges, tunnels. And I think when you look at bridges, you have to interpret that as to what you're trying to define. And if we were trying to define fruit, and it said bridges or something like that, it's got to be defined with what you are trying to define here. And we're trying to define 4-lane highway improvements. And to the extent that there's any ambiguity in that, I think that's cleared up by the ballot title that was put before voters here, that the state's
Counsel.
Yes,
Counsel, do you not think that we have to review this from the standpoint of the voter who voted for this and not use statutory interpretations that we would normally use in statutes?
Well,
aren't we looking at hearing and what the voters saw and the voters' understanding, because they're the one who imposed this tax?
Yes, Justice Ard, and because the ballot title here is the final word. What is the final word here? What are we going to be the final call for what was authorized here by the voters? The only way that the state can use these funds, these special limited tax funds, is from an authorization by the people. So what did the people authorize here? And the final word on that is the ballot title that was put before voters. When a voter, whether they be in Jonesboro, Blytheville, Texarkana, Magnolia, before they go into that ballot box, what are they going to be looking at? We know they're going to have the language of the amendment. They're going to have the ballot title, which is the final word. And that ballot title says specifically that the state's portion of the funds are to be used for improving and constructing 4-lane roadways, not 6-lane roadways, 4-lane roadways. So when looking at what did the voters authorize, it's the ballot title, it's the final word. And the ballot title here specifically says 4-lane roadways. And so we believe it's appellant's position that the language of Amendment 91 is plain and unambiguous, and that the state's usage of these funds was specifically authorized for 4-lane roadways. And also that the ballot title, when looking at the ballot title, as what the voters authorized. The voters authorized these funds to be used for 4-lane highways. And so the state's expenditure on these funds on project CA 0602 and CA 0608 constitute an illegal exaction, and we would ask for the circuit court's decision to be reversed. I'd like to reserve the rest of my time for rebuttal.
Okay, thank you. Court will recognize counsel for the appellees.
Thank you, Chief Justice. Vincent France, Assistant Attorney General for the state of Arkansas, here on behalf of Governor Hutchinson, Treasurer Milligan, Auditor Lee, and Director Walter. I'd like to yield at least 7 minutes of my time for Ms. Rita Looney, Chief Counsel of RDOT. Our plan is to divide this up. I will kind of address everything in our brief, and Ms. Looney will address any issues raised by Mr. Zachary and that the court may have. The
You may proceed.
Thank you, Your Honor. The taxes generated by the tax levied in Amendment 91 have been used to maintain and improve highways and interstates throughout the state of Arkansas. Thus, no legal exaction has occurred. And it's important in this type of case to understand how Amendment 91 came to be. In 2009, the legislature passed Act 374, which created the Blue Ribbon Committee Report on Highway Finance. The purpose of that committee was to evaluate and come up with recommendations and solutions for the current and future long-term plan for financing highways. This legislator also found that the state had a severe and pressing need of its roadways. So the Blue Ribbon Committee met and came up with several recommendations. One of that recommendation was a temporary half-cent sales and use tax to fund highways. In March of 2011, the legislator passed HJR 1001, which submitted that proposed half-cent sales tax to the voters. It wasn't until November of 2012 that the voters actually approved issue number 1. That's what makes this case so unique, is that in a case of really a first impression, because it's the first time an illegal exaction challenge has actually been brought against a tax that's actually levied by the Constitution. And in fact, our Constitution, it only levies a tax in 2 areas. Amendment 75, Section 2, to keep Arkansas beautiful, and there's never been a challenge to that. So in illegal exactions, and so it's important to understand the concepts of illegal exactions and interpreting constitutional amendments, because this case blends them together. And to just look at one and not the other would be a mistake.
Counselor, and I don't want to misunderstand you, but it seems you're trying to make the point that because this was a constitutional amendment, that this tax can't be unconstitutional. But the challenge here really isn't the tax; it's the use of the tax after it was collected. It's not a taxation issue as much as it is a use issue. Is that correct?
Yes, Your Honor, it is correct. And no, I'm not making the argument that it can't be unconstitutional because it's a constitutional amendment. What I'm saying is that when you're looking at interpreting a constitutional amendment, it's important to look at the history of the times. In fact, in interpreting Amendment 23, this court has said that you must look to the constitutional provision is to ascertain and give effect to the intent of the framers and of the people who adopted it, keeping in mind the evils, if any, sought to be prevented or remedied. That was what this court said in Bailey versus Abington. In addition, in that case, this court adopted the legal maximum that the words are subservient to the intent, not the intent to the words. And even more recently, this court had said that it would be myopic.
Counsel, can you explain to me when the legislature voted on the intent other than the stated intent that's in the language here, or when the people voted on the intent versus the language? I mean, the people voted, they had a ballot title in front of them that specifically refers to 4-lane highways. We do have the language within the amendment itself that specifically refers to 4-lane highways. So, I mean, beyond the Section 1 intent section, when did anybody vote on the intent of this? If we have clear and unambiguous language, do we even need to be discussing intent?
Your Honor, I disagree that there's clear and unambiguous language, especially if you look at the popular name and the ballot title and compare that with the language in Amendment 91. This court has said that you've got to read the popular name and the ballot title together. And in this case, issue number 1, the popular name read as follows: an amendment to provide additional funding for state highways, county roads, city streets, bridges, and other surface transportation. The first few lines of the ballot title read, for a proposed constitutional amendment to levy a temporary sales and use tax of 0.5% for state highways, bridges, county roads, bridges, and other surface transportation.
But the remaining portion of that same sentence says, with the state's portion to secure state of Arkansas general obligation 4-lane highway construction and improvement bonds. It's in the same sentence that you just started reading in the ballot title.
Right, in Your Honor. So that's the first time that 4 lanes is mentioned, but that's regarding the title of the bonds. Now, I'll submit to you, if you look at line 11 or down from the ballot title, it does mention that it would be used for improving 4-lane highways. But Your Honor, because there's ambiguity between the upper part of the ballot title and the popular name with the lower part. But it's important to understand, Your Honor, between March of 2011 and November, there was no challenges to the ballot title because the people knew that the funds would be used to improve state highways.
Counsel, I'm a little confused by the way we're throwing around ambiguity, because the question is whether there's ambiguity in a word or a phrase sort of within the amendment, in not, I mean, whether I think what you mean is maybe that the ballot title or is inconsistent with the amendment itself. Not that there's ambiguity, because the terms are defined terms. And again, in section 2, are you telling me those defined terms are ambiguous?
Your Honor, fundamentally, there's inconsistencies, ambiguities between the popular name and the ballot title because it begins by saying it's for state highways. And then later on,
let me ask you this, what is ambiguous in Amendment 91 itself? Is there any ambiguity in Amendment 91 itself?
In the strict reading of the language, no, Your Honor. But fundamentally, Amendment 91 was written by the legislator. And I think it's important to understand that what the electorate voted on was based upon, as this court has said, that the ballot title is the final word. And so fundamentally, our Constitution is the will of the people, not the will of the legislator. And so it's important to make sure that we understand, well, what is the will of the people? What did they vote on? What did they have in that voting booth?
Well, let me ask you this, counsel. If we disagree with that portion of your argument, if the court chooses just to look at the amendment, is there anything in the amendment that would authorize spending this tax on the I-630 project that you can point me to within just the text of the amendment?
Yes, Your Honor. The term 4-lane highway system incorporates not only 4 lanes, but 2-lane highways, 6-lane highways. That
Can
term,
you tell me where that
lane,
defined that way?
Excuse me, you kind of broke up. I'm sorry.
I'm sorry. Can you tell me where that term is defined to include 2 lanes, 6 lanes, or anything else?
Yeah. Your Honor, that term it's not specifically defined in Amendment 91. Its terms originated back in the 50s and 60s when the federal government was putting out all these regulations for the interstate system. And they determined that 4 lanes was the gold standard. So Arkansas took that to interpret the 4-lane highway system would be the gold standard, and has kind of applied that term as the ideal that we would like to get our state to. And this court has said, it's important to look at the history of the times because we do got an inconsistency in the ballot title and the strict language. And so the history of the times, it was clear that the state had a severe and pressing need of, its roadways. Also, Your Honor, in the intent section of Amendment 91, it does state for state highways and the state highway system or the state system of state highways. And so,
Counsel, what is ambiguous about limited to spending money on 4-lane highways? What is ambiguous about that? That the money is limited for expenditure to 4-lane highways. That's what the people voted on. And you tell me what it is that they couldn't understand about that.
Your Honor, I disagree that they voted that it was a 4-lane highway. I believe that
I'm
they voted
asking you to look at your ballot title and see what the ballot title limits the tax to be spent on, the state's portion.
It doesn't limit it when you read it in its entirety, because it starts
When
off
you
by
read
saying,
that whole ballot title, you're saying that the people thought that they were going to give the legislature or give the highway department the freedom to just spend this the way they wanted to?
they didn't give them the freedom to spend it the way they want. They gave them the freedom to spend it
They gave them a limited purpose. Is that correct?
for state highways. Yes, Your Honor.
For 4-lane highways.
I disagree with you, Your Honor.
But show me where in the amendment that you have any basis in the written word to disagree with that proposition. You have it in front of you. Just show me where it is.
Yeah, it's in the intent. The intent section 1. It says, talks about how the state, there's an antiquated and outdated system of state highway funding, and that increasing investment in the state highway system in section B. Also, as well as in section 8, it mentions it's for state highways.
But it limits it to the 4-lane highways. We were outdated on the 6-lane highways at the time that this was passed, were we?
I'm sorry, Your Honor. I think I missed the first part of the question.
At the time they passed this, we weren't outdated on the interstate system. We were outdated on the system to get within the areas of Arkansas, not
Your Honor,
get from one state to another.
Your Honor, the portions of the interstate system are part of the 4-lane highway system as defined by the Highway Commission.
Do you see anywhere in this Amendment 91 where they mention interstate or 6-lane highways?
Your Honor, Arkansas is responsible for the interstates, and the Arkansas highway system includes the interstates.
I didn't ask you that. I said anywhere in this act do they mention interstate system or 6-lane highways?
No, Your Honor,
people are
because
looking at the vote on it, and where would they find that they're going to spend this money on interstates or 6-lane highways?
Your Honor, because those are part of the state highway system. The interstates are part of it.
So define it? Is it so defined in the article? Isn't it there? The definition there is we're going to spend this money on 4-lane systems.
But the intent says that we're spending on state highways system.
But it doesn't say 6-lane, or it doesn't change what the 4 lanes does it.
No, Your Honor. But
thank you.
Counsel, on that same point that Justice Hart raised, I mean, you've mentioned a lot about the intent, but again, I think to the extent that we consider intent at all, it's the written intent that's in the amendment that was voted for. And if you look at the intent section in Amendment 91, Section 1, Part B, the second part of that states that specifically a 4-lane highway construction plan designed to connect all regions of the state. And I'm not sure how work on I-630 in the middle of Little Rock furthers the intent of connecting additional regions of the state.
Yep. Your Honor, I can assure you that the voters were informed of all the project, because in the 19 months between when the legislature passed HJR 1001 and when they voted in November, in May of 2012, the Highway Commission, in a minute order, adopted all the projects that were to be funded if Amendment 91 was passed. And this court has said that minute orders of the Highway Commission carry the same weight as statute. And so the people were put on notice as to what these funds were going to be used for. And so, Your Honor, just so I have a little bit.
Is there a difference of being put on notice versus including it in the language of the amendment? I mean, to look at anything outside of the amendment, don't we have to first find ambiguity in the amendment itself?
Your Honor, the true ambiguity really exists between the ballot title, popular name, and the amendment. And by looking at the intent,
I think that's a different standard, but I do notice the time I noticed when you started that you wanted to reserve some time for Ms. Loney, so I'll stop my questions.
And so, Your Honor, I would just to summarize a few things is that, again, the true ambiguity is what was on the ballot title versus the amendment, and that the intent controls. Excuse me?
I said, are you sure you haven't made up that ambiguity? Is it a matter of just deliberate misreading of that or adding to the statute in order to come up with that?
No, Your Honor, I completely disagree. And so, because everything I've said, and so the intent controls over any strict reading of the Amendment 91. So on behalf of my clients, we would ask that this court affirm the decision of the circuit court, and I'll yield my remaining time.
Counselor, you said intent would rule over the plain language?
The strict reading, yes, Your Honor. This court adopted that proposition in Bailey versus Abington. Unless there's any further questions for me, I'd like to yield my remaining time to Ms. Rita Looney.
May it please this honorable court. It is my privilege to represent the Arkansas State Highway Commission and the Arkansas Department of Transportation in this appeal before your honors today. The circuit court correctly found that the intent of Amendment 91 was to fund state highways, and the ambiguity about which all of you have been inquiring this morning was evidenced through the filings of the plaintiff in this case, in that they filed an illegal exaction 9 years after the passage of this constitutional amendment, and amended the complaint twice. So they had 3 complaints. First, including interstates. Second, modifying 4 lanes to say 4 travel lanes, inserting their own term in between because they felt it was ambiguous, and they were talking about 4 travel lanes and not just 4 lanes. We have collector distributors. So they added that term. That complaint was, the court dismissed that. They amended again to limit their complaint to 2 projects. And I would submit to you that as to get their foot in the door before this court and before the circuit court, the only way they could sue the state was to claim an illegal exaction. But they didn't claim an illegal exaction because it did not occur. The State Department of Transportation and Highway Commission were authorized to spend this half-cent sales tax for the very purpose that was stated in the ballot title for the improvement of the state's highway system. And that state highway system, 4-lane highway system, is not defined. 4-lane highway improvements, I will give you, that is a defined term. But even the plaintiffs in this case were confused about what their own case was and what they were complaining about, because really they were just complaining about an expansion or improvement to an interstate facility within the state, within the city of Little Rock. I would tell you that the court needs to keep in mind what was the object sought to be accomplished by the amendment when it was passed. And that object was to fund state highways. As far as what that voter had in mind when they went into the booth, they had in mind, I would submit to you, that just like a juror, they don't leave their common sense behind. And I don't think a voter went in and thought, I'm going to vote for this because it limits the state to what they can spend it. But, oh, interesting that amendment doesn't limit the cities to 4-lane highways. It doesn't limit the counties to 4-lane highways. It only would limit the state.
Excuse me.
I don't.
Excuse me. The amendment reads, the people of the state of Arkansas finds, and then it says to provide additional funding for the state's 4-lane highway systems, county roads, city streets. That's what they provided. And do you have any evidence that they put on what the people thought they were voting for? Or did you just make that up?
Your Honor, the testimony before the court, and the court is before the trial court, was presented by appellees, by the appellants, and they elicited testimony from the director of the Transportation Department, as well as inquired about the Blue Ribbon Committee report, and all of those at the public meetings where the voter had opportunity to see what was going to be built if they voted for this. They had the opportunity to see that before they voted in November of 2012. There was more than 6 months time in between the time.
Can you address provision C of what you're talking about there? To provide additional funding for the state's 4-lane highway system, county roads, and city streets. And you're saying that they didn't address the streets within that? But does Amendment C specifically provide what you can spend money for?
Yes, and my point in answering your question, Your Honor, is that when the legislature wrote Amendment 91, and it was before the legislature didn't limit this. It's hard to believe, and it would be absurd to believe that they would limit themselves, the state, in how they could spend money, but not limit the city and the counties, because there was no limitation as to what types of facilities the cities and the counties. It would neuter the highway department's ability to improve the majority of interchanges, but also rural highways that go across the entire state. It would be absurd to think that the legislators and the voters believed they were voting to limit improvements to the highway system. They were instead voting to improve the state's highway system, not select roads. They wanted their system improved, and
So Ms. Looney, that seems to be an inconsistency in your argument, because you just made the argument that the people knew about this minute order that had specific road projects included, but now you're saying that it was just a system improvement that they wanted and not specific roads. I mean, I think our law is clear that when the language of the amendment is clear and unambiguous, we don't look outside to anything else for intent. But if we were going to look outside to what the voters thought, and I think it's a big stretch for you to do that, I think it's a big stretch for me to do that, but if we were going to do that, I think history would show us that what the voters were told is that the people in El Dorado and Jonesboro and Mena and Mountain Home and all over the state in these rural areas were told, hey, this is going to get rid of those little windy 2-lane roads you all have to deal with. This is going to give you some 4-lane highways. And this is, as Section 1B says, this is going to connect all the regions of the state. I mean, I don't think we look at those sales pitches, just like I don't think we look at the minute orders. I think the language is clear and unambiguous, and I think that's where we stop.
And Your Honor, you are exactly right in that they were information presented to the voter as to what they were voting on was a 4-lane system throughout the state, and only 13% of those funds that have been raised have been spent in the urban area of Little Rock on the 2 projects about which the plaintiffs complain. The other percentage has been spent in rural areas. You've got the highways and across 412 across Northwest Arkansas. And that is the 4-lane grid system. And the 4-lane highway system includes the interstate highways. It has always included it. And that minute order, which has the effect of law, is indeed was supported by the people when they voted to have their system improved throughout the entire state. And I would submit to you, the plaintiffs did not prove an illegal exaction because there was none. And that's what this case is all about.
Ms. Mooney, I'm going to ask you to cover one more topic because we haven't covered it on your side, and I know we're short on time here. But Justice Wood raised the issue with the appellant earlier. In Section 2, we have these modifiers, and we've got 4-lane roadways, and then we have bridges, tunnels, engineering, rights-of-way. I haven't heard anything about any differentiation between the bridge aspect of the I-30 project versus the I-630 project.
Thank you, Your Honors. The court dismissed that at summary judgment and said that the bridge project was properly being funded because there was no limitation on the number of lanes. And so to the earlier inquiry regarding the grammatical status of the amendment, you are exactly correct. There was no limitation to lanes on bridges, which is why it brings about the absurdity that you could have no limitation on a bridge, and the court so ruled and eliminated that from consideration at the final hearing, but you would have a limitation on the number of lanes approaching that bridge. The absurdity is, it comes to mind, and when looking at the entire amendment as a whole and reading it with the eye of the intent of the voters and what they were voting for, I'm convinced, and the court was likewise, by the evidence at trial, that there was no illegal exaction. The Highway Department and Highway Commission did not spend these funds to build a new building. We did not spend these funds to buy furniture. We didn't build an engineering department at one of the universities. These funds were built to improve the state's highway system, and the court ruled.
But not the 4-lane system.
Yes, indeed,
Excuse
the
me.
4-lane highway system.
You spent the money or intend to spend the money on a system that is outside of this amendment levies a temporary sales and use tax and authorizes general obligation constructions and improvement bonds for the state's 4-lane highway system, and you intend to expend that money outside of that definition.
No, Your Honor. The 4-lane highway system is inclusive of the interstates and has been by a minute order, which has the law as issued by the Arkansas Highway Commission. The 4-lane highway system is inclusive of the interstates throughout Arkansas, and that would include those facilities about which.
And you think the state highway system can overcome a constitutional amendment that was voted by the people?
Your Honor, I think the people voted for the improvements that are being made on the 4-lane highway system pursuant to the amendment itself and the appropriate authorization that the department and the commission was given to improve the 4-lane highway system to all parts of the state of Arkansas, which is where most of the funds have been spent. I would submit to you.
Miss Looney, you just mentioned that you didn't build an engineering building. And I'm looking back here on the definition and G1, and then it goes through a list, A, B, C, and D. D lists engineering. So I guess according to your broad argument here, you could build an engineering building because it says D, engineering, E, right of way.
Engineering, I meant a facility like a library or an instructional.
Exactly, but if we go back.
Engineering,
Pardon me, I'm speaking. If we go back here to look at this list and we were to see bridges, tunnels, engineering, right-of-way, if we read those broadly, then the absurdity of you all building an engineering building, just as you suggested, is how that would be the natural effect of a broad reading.
Your Honor, engineering is a professional service. Those are costs that are incurred in building highways, and right-of-way is an acquisition cost that is incurred in building highways. So I would submit to you that yes, that could be a very broad reading, but to say that the funds could be used for engineering did not mean that the funds could be used for building a physical facility or to buy furniture and that kind of thing. That was my point. I appreciate your question. Thank you.
And Ms. Looney, your time has expired. Let me ask, are there any other questions? Okay, thank you. And the court will permit rebuttal by the appellants. You're still on mute.
This is an issue of constitutional interpretation, but the appellee's argument goes past the very first rule of interpreting this state's constitution, that when the language of the amendment is plain and unambiguous, the court's analysis stops right there. They go past this rule because they readily admit, if you looked at the language of the amendment, there is no ambiguity. As far as the history of the times, I'd like to just address that real briefly. There were when the legislature referred Amendment 91 out to the people to be voted upon, there are actually two highway funding bills that came out of the legislature that session. One was what would become Amendment 91. And the second was the Arkansas Highway Financing Act of 2011. Arkansas Highway Financing Act of 2011 greatly tracks the language of Amendment 91 as what's authorized under that act. However, the Highway Financing Act of 2011 is general in nature. It can be applied to interstates generally. Amendment 91, on the other hand, specifically only authorizes 4-lane highway improvements. Another point brought up by the appellees was complaints being amended. Complaints get amended in litigation. For example, the appellee's first answer in this case actually stated that the language of the amendment speaks for itself and provides the best evidence of its meaning. Pleadings change. Pleadings get amended as discovery progresses. As far as the absurdity of the results, there have been 36 construction projects funded with the state's portion of Amendment 91 fund. The two projects being challenged here by the appellants are the only two projects that go to improve an existing 6-lane highway. The other 34 projects that receive state funding go to improving and constructing 4-lane highways. It was readily admitted below that when the legislature referred Amendment 91 to the people to be voted on, no projects have been chosen. It was readily admitted below that no projects were included as part of the ballot title or popular name presented to the people to vote for. These are the only two projects that do not go to improving or constructing a 4-lane highway. That's why these are the only two projects appellants are challenging. As far as the different limitations between cities and the state, cities do not have jurisdiction to do construction on the state's interstates. The city's funds that they get are specifically under and fall under the City Aid Act as well as the County Aid Act. It's the state's portions here, the only ones being challenged. It's the state's portions that were specifically authorized to be used on 4-lane highways. The appellees readily admit you have to read the popular name, the ballot title, and the amendment all together, not just part of it, all together. You can't read section 1 without section 4 and 2. And looking at section 2, the definitions, getting back to Justice Wood's point, constructing and improving 4-lane roadways would only include bridges on 4-lane roadways. The ballot title makes this clear that the state's portion was to be used on constructing and improving 4-lane roadways. If there's no other questions at this time, we court to reverse the circuit court's decision.
Okay, thank you. Thank you, Mr. Zachary. And that concludes our oral argument today. And court will be adjourned. Thank you.